This video covers key topic number 6 in our workshop, protecting your assets in case you have to go into a nursing home. Again, I recommend watching these topics in order. Now that we've learned about a lot of the background information, we're ready for key number 6, plan when you can.
Key number 6 to saving your assets and creating an estate plan is planning when you can. Why should you plan? Well, you should go ahead and do it to keep it simple for your family. It goes ahead and establishes who has control and who has access to your stuff in the case of disability or death. Why do it now? Well, as we discussed, was particularly with the irrevocable trust. If you do it now, then you can go ahead and establish things and have them set up so that you can get past the 5-year look-back period for Medicaid. Also, it's also less stressful for you and your family to do it now than when you're dealing with a crisis. Very few people have ever said that, yes, they're better off trying to do things when a crisis has occurred than trying to do them in advance when they have the luxury of time to be able to sit back and plan how things need to go. So, what type of plan do you need? Well, you have a few options with that. The first option is a basic estate plan. That would be a will, so at least that you can decide and not the state as to what happens to your stuff after you die. A healthcare directive that is HIPAA compliant. And I mention this because sometimes people have done estate planning in the past, back before HIPAA was ever a law, and their healthcare power of attorney doesn't mention HIPAA in it. So I always recommend that even if people have done estate planning in the past, go back and look at your healthcare power of attorney and make sure it says HIPAA in it. If it doesn't, you can do a new one. That's not a problem, but it's at least something you should look at. And finally, a basic estate plan would have a power of attorney, which is something that everybody needs. I get asked all the time, when should I start doing estate planning? I basically answer to people, are you over 21? Are you married? Because the basic estate plan with a will and particularly a power of attorney can be so important. Because what the power of attorney does would allow you, for example, to give the power of attorney to your spouse, so that if you should ever become, say, incapacitated, they would still have the ability to do the things that need to be done on your behalf without having to go to court and get a guardianship, which the whole problem of trying to go to court and get a guardianship would be bad enough in the case of somebody being suddenly incapacitated. But in Kentucky, it's a particular problem because Kentucky is literally the only country or the only state left in the country that requires that guardianships be established by a jury trial. So certainly everybody needs to have at least the basic estate plan with those 3 items. But the second option would be your rule book, which would be a basic estate plan with a revocable living trust. And that would allow you to provide all the rules that you want for your life, disability, and death. And then the third option would be the asset protection plan, which would include the basic plan, the revocable living trust, and an irrevocable trust, probably with just your house in the irrevocable trust. That would allow you to have your rule book with asset protection during your lifetime. It provides all the benefits of the open box revocable living trust and protects your key assets, your stuff, from predators now and in the future when you go to apply for Medicaid.